that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask, is the police saying that they are unable to secure and safeguard the safety and interest of its citizens? In the threshold of that, Your Honor, we plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators or by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both lean as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, Your Honor, and that if they are limited, it would not in any way prejudice the investigations, as nothing would bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with Your Honor that you admit the respondent to bail bond pending this investigation, and in the event of such disinclinement, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Benignly, we submit, Your Honor.
Okay, Your Honor, I was thinking that the collection that was going to say something, but let me start with if whatever wants to add, you can add. But your last committee submits to yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent to this matter. Please grant it. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably today. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus OM of case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mingi mkonazo mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal in the realm of the Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that. Then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they did not tell you is that he gave them the passwords and they are keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the window. Let's finish that one. It's a simple thing, a 1-minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given you a password. Pick a password. It's not about the password. Give the code. Just it's not about the password. They're telling you.
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
No. Your participation. I'm running the show.
Okay.
Now, they're telling you about witnesses. They are not telling you in the affidavit which witnesses, but they're telling you something else that is imaginary, that they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement.